I want you, for the length of this video, to believe that feminism is all about the social, political, and economic equality of the sexes, and nothing more, just that. American statutory rape laws are mostly based on English law, which suggests that a female, not a male, a female, under the age of 12 years is incapable of consenting to intercourse. In 1859, the California Penal Code Section 261.5 titled Unlawful Sexual Intercourse with a Female under age 18 defined unlawful intercourse as an act of sexual intercourse accomplished with a female not the wife of the perpetrator, where the female is under the age of 18 years. The law sought to exclusively protect minor females, effectively attacking the equal protection principles of the Constitution as defined by the Supreme Court in Michael M. v. Superior Court. 17-year-old Michael M. was charged with statutory rape for engaging in sexual activity with a 16-year-old girl. The defendant argued that the gender-based definition of statutory rape implied that only men could be booked for rape. California justified the gender-based definition of statutory rape on the grounds that it was aimed at minimizing teenage pregnancies and that gender neutrality would reduce the effectiveness of enforcement and females reporting violations. Justice Rehnquist, in writing for the majority, argued, quote, "Young men and young women are not similarly situated with respect to the problems and the risks of sexual intercourse. Only women may become pregnant, and they suffer disproportionately the profound physical, emotional, and psychological consequences of sexual activity." The judge argued that pregnancies deter women while nothing deters men, and as such, a legislature acts well within its authority when it elects to punish only the participant who, by nature, suffers few of the consequences of his conduct. A gender-neutral statute would frustrate its interest in effective enforcement. A female is surely less likely to report violations of the statute if she herself would be subject to criminal prosecution. We decline to hold that the Equal Protection Clause requires a legislature to enact a statute so broad that it may well be incapable of enforcement. Justice Brennan's dissenting opinion that was joined by Justices White and Marshall invalidated the ruling, arguing, "The state has been unable to demonstrate a substantial relationship between the classification and its newly asserted goal of preventing teenage pregnancy." Justice Stevens suggested that the only acceptable justification for a general rule requiring disparate treatment of the two participants in a joint act must be a legislative judgment that one is guiltier than the other. California successfully defended its gender-based rape law in the Supreme Court for 122 years. One of the primary arguments fronted by the state of California revolved around equalizing deterrence for sexual activity because females have a natural deterrence. This logic therefore implied that gender-neutral statutory rape laws would deter females more than males. So how would the state punish participants? How about if the older participant was female with the younger one being male? Within 12 years of the Michael M. case, California switched to a gender-neutral law. In 1993, the word female in the law was replaced by spouse, minor, and person. The laws focus on the age of the defendants, with a difference in 3 years not resulting in imprisonment. However, when the perpetrator is above 21 years and the victim is below 16, then the activity would result in a maximum prison time of 4 years. So what led to the changes in the state of California? In 1992, Marsha Beckerman's teenage son was seduced by a 40-year-old woman, Faye Abramowitz, who used alcohol and sexually explicit videos to entice Beckerman's son and other boys into intercourse. Abramowitz was charged with oral copulation and other lesser crimes but not statutory rape. Beckerman felt that her son did not receive justice because Abramowitz pled no contest and got 5 instead of 7 years and 8 months. District Attorney Craig Richmond believed that the circumstances surrounding the case met the definition of statutory rape, but only if the perpetrator was male and the victim was female. Such charges would accrue up to 3 years for each sexual encounter. Beckerman argued that the old law implied that only girls could be victimized, while boys could not. Two lawmakers, in responding to Beckerman's arguments, sought to make statutory rape laws gender-neutral. Apart from Beckerman, 2 teenage boys, A.T. Page and Mark Searle, testifying of being coerced into the sex by their high school football coach, Randy Brown, who required them to have sex with his wife Kelly Brown, also informed the legislation of gender-neutral laws. Neither of the Browns was charged with anything because sexual intercourse with a minor was not illegal. The couple pled guilty of lesser charges amounting to solicitation and oral copulation, which led to suspended prison sentences and 5 years probation. The conclusion of the case led to Page and Searle speaking publicly against the biased statutory rape laws. The boys' testimony was supported by mental health experts who indicated that gender was not a factor in statutory rape-related trauma, which manifests through intimacy issues, withdrawal, and depression. Feminist scholars ideologically and practically challenged the gender-centered definitions of statutory rape. The ideological criticisms revolved around the double standards observed in the law, presenting women as sexually passive and men as active. While the double standard is ideal in protecting women under the law, presenting women as sexually passive goes against feminism's push for sexually free women who could express themselves just like men. Traditionally, men are viewed as active through the constant initiation of intercourse, while women were passive since they didn't initiate any. Thus, any engagement in sexual activity by a male is often perceived as an accomplishment, especially if the woman came onto them because they didn't have to work as hard. The practical criticism revolved around oppressive restrictions against young females through government intrusion. Some feminist scholars argued that the gendered laws violated minor females' rights to privacy and consent to intercourse as freely as their male counterparts. Other scholars argue that a woman seducing a young man and an older man seducing a younger woman should not be treated equally, with the same scholars believing that the patriarchy manipulates women's sexual freedom to exploit women. This despite the fact that it is more natural for the man to be older than the woman in an intimate relationship. Gender-neutral laws effectively deal with the harmful stereotypes surrounding male and female sexuality. The laws support the fact that males could be victimized by females, and not every encounter is perceived as an accomplishment by boys. Even with the legislation of gender-neutral laws, how effectively are they implemented? This question is particularly significant following the recent overturning of Roe v. Wade, and especially the arguments surrounding the plight of underage female victims of rape who are denied access to abortion services across half the United States. Feminists and like-minded people argue that it is unfair for victims of rape to be forced into parenting by denying them access to the necessary services. While forcing women, especially young girls, who are or are not victims of rape into parenting sounds unfair, forcing men and young boys, who are or are not victims of rape, into parenting is quite common in America, and surprisingly, very few people, if any, have a problem. In all these cases that will be discussed in the next video, men not being afforded the luxury of opting out of parenting as women are through a wide range of options extends even to victims of statutory rape who are legally forced into paying child support, even if the female perpetrator was charged with statutory rape and successfully convicted.